No, he saw me.
He's getting it ready. There he goes.
Call the meeting to order at 5:35. Everyone have a chance to review the minutes?
Yes, I make a motion, accept the minutes as written.
Seconded.
All in favor?
Aye.
Bills.
Yep. Don, you're on your own.
Gail Santos mileage.
It stopped again.
We must have paid her to go to vacation.
Gotta get far on that one. This is a little light reading for you in correspondence. Okay.
Where's that Gail Santos one? Take my name off it. What is that for?
It's for the casino.
Anybody want a casino?
That's for the slots.
Yes, slide it down.
That's what's-
Can you read this? Because in Paul's absence, you do have to do the reading.
Yeah. Should I start now? Why not?
Oh, shoot. All right, quickly. I'm going to go right into informal. We're going to deal with
It's
the
in
Doug King
correspondence.
property.
It's in correspondence.
Has everyone had a chance to review some of this King stuff? Okay.
Yep.
Number one, I need a motion. I believe we have to retain Marty Nova, and I want it to be official. There are several issues on the site.
Okay.
If they start work, there will be issued a cease and desist. At this point, she sent out the letter, on my word.
Are we retaining Marty under the new bylaw?
Yep.
No, because the new bylaw doesn't apply because it's already an existing order of conditions, so we can never make them pay for it.
Okay.
So we are gonna have to pay it. We have money in the wetland fund.
We do.
Don't let him come in.
Yeah, I know, but they don't want cooking.
All right, I'll make a motion that we accept,
Retain.
retain Marty Noah Armstrong for the project of, let me get the,
Do we have a DEP file number on that, anyone? It's gotta be here somewhere.
Yes.
I got it. For DEP, file number SC 269-0888, 512 South Street East in Raynham for wetland restoration activities.
As you can see, she came up with several things, okay? We walked the site today for about 2 hours. That was my first time on that site, and I was educated. The way she wrote the order of conditions and the special conditions, they have to do all the ditch plugs at once.
Okay.
Okay? So, and there's supposed to be a pre-meeting that hasn't happened. There was supposed to be more plans. The crossover pipes,
Right.
the connection
That's right.
pipes
Yep.
are at the wrong elevations. I mean, there were several things that needed to be corrected before they could put a shovel on the ground.
Okay.
So, at this point, if we catch them out there, we'll shut them down
Okay.
until all these other parts are in play.
Okay.
As of right now, they haven't done anything. They said they were gonna start, but they haven't, and this letter went out, so we assume that they're,
Are the hay bales in?
there's hay bales in for 2 of the ditch plugs, but not the third one, which was the special condition.
Okay.
And after walking it, I mean, it's understandable why she wanted it.
So I have my motion on the floor.
Seconded.
All in favor? Aye.
Aye.
Did I vote on it already? No?
No.
No, I made the motion.
Okay. Okay, so we're all set. All right, so that's taken care of. Is he out in the hallway, or
Yep.
where is he? Azu!
He's probably in the bathroom now. No, he left.
You're going with that.
Yeah, you made him feel bad.
Finish the correspondence.
We can't.
Okay. Do that one. Oh, that one.
How do I want to handle that? Just
Oh,
go
why don't
find
you wait,
him, Leah.
because he spoke with you today.
Okay.
And then I'll have Bill read it.
We gotta see what we have to do.
Oh, I still,
We'll wait for
we'll
that.
have to we need date for that one anyways.
FEMA's gonna have they're going over the maps again for the flood maps. And they're gonna have a hearing, or you can review the maps if anybody's interested, Monday, September 16th, at the Lakeville Post Office.
Do you want somebody from our commission to go?
I don't think it really matters if you want to.
What's,
You can get the flood maps if you go, I think.
I think we get the maps, and maybe,
Okay.
I won't be able to go, I'm gonna be in the vineyard. so-
I'll be around, I'll make it.
Okay.
I'd like to go, but I won't be here.
The only thing I would do, Kevin, is to call and double check those times, because.
Okay. I
one
hope those
says-
times.
One says it's in the afternoon from 9 o'clock to, so,
No, there are two.
There's
Yeah.
two, one's in Attleboro, if we don't make the Attleboro one, I mean, if we don't make the Lakeville one.
right.
On the, oh, it's the same day, they're both the same day.
Right. One's at 9 o'clock in
Right.
Attleboro, and the other one's in the afternoon in Lakeville.
Lakeville, sorry. I should be able to make the Lakeville one.
Did you read this from the EPA?
No.
It's to do with Walmart, the vote. It's their orders, their agreement for the removal of all the PCBs and everything else that they're in the process of finding. That is underway. That's all done under the federal guidelines, so. We have a book with pretty pictures in it.
And all your stormwater magazines if you want them.
How to cut a tree.
I don't get them now.
Okay.
I think there is a stormwater class coming up through.
There is.
There is.
That I want to try to attend. It's close, isn't it?
It's November, I think.
Yeah.
Just, all that stuff is in the office if anybody ever wants to come in and take a look at it, so.
There's another book on stormwater. Do you guys ever read this stuff? It's interesting, some of the new stuff that's out there.
Some of the stuff that gets pushed out by the NACC online that we look at.
This might be a good thing for, because it's got all the different stuff in it. Somebody want to go find him? Because he's lost. Where's the George thing?
Hey, when he walks in, you should ask him if he has reviewed this.
But you can't vote on it. So we need for David anyways, right?
Yeah.
So we can't do that one. How about the access road?
You can ask Kazu if he's done his homework and read this yet. He's got to give us
He put it aside.
He's got to give us some quick cliff notes.
He read it this afternoon while he was waiting for me, because I was late this afternoon, so this is just payback.
You got the cliff notes for this?
Later than you.
Oh, wow.
We made him sit out front and wait so that you wouldn't feel like you were the last one in.
Oh, okay, sounds good.
And then we push him to the end.
Pass that to him, I think we have to wait.
This one here, we have to wait for David to get here to vote on, because Bill can't vote on it, correct? Okay.
Yeah, pretty good.
Yeah.
The emergency access road that runs from Catherine's Way to North Main Street by Hewitt's Pond, the town will be out there doing some tree cutting to reestablish the width of the road and the height of the road so that the fire engines can pass on that road. Just so everyone knows, that's going to be taking place tomorrow. It's starting tomorrow with they're going to have a truck in there doing the high stuff. And then the town will be coming through afterwards to get everything lower to get the width back. What else do we have?
That's it.
Moving to informal, issuance of an order of conditions for DEP file number 269-0899, Stephen Joyce, Christina's Path, map 9, parcel 7-6.
We had been waiting for information from the Pat notes, and Isaac received the information, and
Yeah.
we reviewed it,
Yeah, sure,
so it's all
sure.
set to go,
Tell us how to,
to sign, yeah.
Order conditions also.
this has already been
Yeah, it was,
Yep.
voted on and
Yes.
yeah,
everything,
we
right?
talked about it last time. We asked him to change the slope of the driveway.
Certificate of Compliance, DEP file number SE 269-0856, 480 South Main Street.
This one is the one that had the partial certificate a few months ago, and they were finishing up the work on it, and then now they're requesting a complete certificate of compliance.
Yeah, that's the one that.
Are we all set with that?
Yeah.
Okay. Do we have a motion?
That's a
Motion, for which one?
A certificate of compliance for 60,
No,
480.
480 South Main
A
Street.
motion to issue a certificate of compliance with DEP file number SC 2690856, 480 South Main Street.
Second.
All in favor?
Aye.
Unanimous.
Thank you.
Do I want to wait for David, or just keep going?
Yeah, keep going except for the below one.
Okay.
And really, you're not gonna take any action on the Bonilla one, really, it's just basically an update.
Enforcement order for RK Associates, 600 South Street West. We had voted to issue, to have a notice of intent filed, and that has gone by. There was a request, here he is now. There was a request to give them an extension. What do you want to, where are we going with this at this point? Anyone got any comments on this?
On the enforcement order,
Yeah.
well, the enforcement order still stands.
Can I approach?
Podium, please. State your name for the record.
Good evening, my name is Anatoly Darov. I'm an attorney with the law firm Burns Levinson, and we represent RK Associates in connection with the enforcement order.
Okay. Number one, no notice of intent filed.
Correct. So our position on the matter is that the area that in question, the area of concern, is not a wetland under the Wetlands Protection Act. So my client has an issue with filing a notice of intent. What we've proposed and what we've done is we've prepared a request for determination of applicability that we would like this board to consider. And, I think that, considering that RDA would put this back on the right procedural footing. And I think we've put forward some evidence in that request for determination of applicability that sets out, we think pretty clearly, that it's not a jurisdictional area. My client certainly is not opposed to taking any of the remedial steps necessary to replant trees. I think they've proposed to replant more trees than they cut down. But they just have an objection to the fact that this is going to set some precedent to this area being a jurisdictional wetland, which it is not. I think, as you know, MassDOT has filed an NOI for work in the same area. But I think the difference between what MassDOT did and what we're doing is that MassDOT's NOI applied to an entire corridor up and down Route 24. And the work that we're doing is a very limited area in this one quadrant of the interchange. I believe you have a copy of our request for determination of applicability. We'd like you to consider it. We're happy to come to the meeting on the 18th, where we hope it's considered and answer questions and make a presentation at that time. And let me just say that the That's one option, is to consider the RDA. The other option would be for the board, for the Conservation Commission to amend the enforcement order and simply remove the requirement that we file an NOI. Because if that requirement is removed, our case prepared to do all of the mitigation, work with MassDOT and do the plantings. They're ready to do all of that. They just don't want to make the NOI filing. So I think there are two options to go.
At our last meeting, RK was more than willing to get this taken care of in any way possible. Since then, they say it's not a wetland, that it's not a stream, that it's not buffer zone in any way, shape, or form. I have a map downstairs from 1855 that shows it as a named brook.
That's not what we see from the scientific data and from the field work that we have done. And Frank Postum is here from EA, who can talk in detail about what we have done in the past 4 weeks to get out there and do a complete wetlands delineation. And we just, it may have been, that hydraulic connection may have been there for a long time, but our point is that that doesn't make it jurisdiction under the wetlands law.
Okay, number one, we have a couple of issues with an RDA. Number one, there would be consulting fees that would need to be, we'd need a check deposited in order to have this reviewed. I've spoken with our consultant, and he was going to prepare an estimate, correct? We spent considerable amount of time out there today. I haven't seen an estimate yet.
No, Mr. Chairman, only because I haven't had an opportunity to put together, but...
You were 10 minutes late, I left you 45 minutes
Right.
before that.
But at least preliminarily, you were just, depending on what they're looking at, I'm obviously submitted a substantial material in the RDA, but I will throw this out just for the time that I was there. You might not make the argument that it is bordering, you can make the argument that there's no bordering vegetated wetlands, even though you have Phragmites and the Catanites growing out there, that you can say, well, that's invasive species. But you do have a stream bank. A bank is a resource under the Massachusetts Wetlands Protection Act. A bank is a resource, and it does also have a 100-foot jurisdictional boundary. Now, the commission takes the position, and can be justified as such, that stream is not even intermittent. Even if it were to be held as intermittent stream, it still has a well-defined bank. And the Wetlands Protection Act clearly requires or applies a 100-foot jurisdictional boundary from a stream bank, whether it's intermittent or perennial. We will probably take the position that not just that it's intermittent and it's a bank, but actually it's perennial. Now, there are two basic requirements. Either it's a solid blue line in the USGS quad map, or a stream stat can be done. And I will submit to you that at least the tributary area to that stream is more than half a square mile. So that right there in the Act does talk about that. So you might make the argument that I can see, I'm not saying that I agree, because I haven't done a full evaluation, but one can make the argument that, well, perhaps there is no BVW, bordering vegetated wetlands, but clearly either intermittent or perennial. There is a bank resource. So basically, you're either talking a 100-foot jurisdictional boundary from the bank, in the case of intermittent stream, or 200-foot riverfront in the case of perennial stream.
Yeah. I'll ask Frank to come up and just talk about the classification of the bank, but my understanding that, to be a bank, it has to be a bank that abuts a stream that goes between a body of water or a body of water and a BVW or a body of and some upland. I mean, it is a bank in the sense that there is a hydraulic connection there, but it doesn't fall under the definition of a protected bank or a jurisdictional bank under the Act. I don't know if I missed anything, Frank, if you want to add anything to that, but.
Before we get into all the technical arguments, I have one question for you. Your client last meeting said that he'd do whatever he could to get this rectified, and he admitted that it was his mistake. Just file the NOI and get it over with and get it done, instead of all this argument. We're missing time now.
We're not even gonna get trees in.
Yeah, we're.
That's the part I don't understand. You can argue all day long. He says it's bank, you don't say it's bank, you say there's a frog there, he says there isn't.
Right.
You can argue that all day long,
Mhm.
okay? We're not getting anywhere to fix it like your client said he was gonna do.
Yeah, we're ready to go in there and do the remedial work tomorrow.
Then stop arguing.
and-
Do the NOI and get it over with.
Yeah.
And nothing has changed, by the way, from what my client said at the last meeting when they appeared. They're ready to do it. It's really a legal issue. That's all it is. And I think you've put us in this position because
We didn't put you in any position, sir. Your client did wrong. We did nothing wrong. Your client got caught doing wrong.
well,
We didn't put you in a position. You came in here because you did something wrong.
what we're telling you is that we didn't do anything wrong because it's not a regulated area. We'll fix it. We want to be good neighbors and good corporate citizens. We'll do the plantings, but what we're telling you is that we didn't do anything wrong because it's not a regulated area. If it had been a regulated area, if we determined that it had been a regulated area based on our scientific and field work, engineering field work, we'd file the NOI. But it comes down to a legal issue. They don't want to set the precedent that this particular area is a jurisdictional wetland, because then it puts the property within the boundary, and that's not to their.
You do anything on that property from here on out, it's still going to be considered a violation,
Why is that?
because we still consider that bank. At the very least, it's bank. We see a connection from a wetland.
There's a very extensive wetland system, albeit on the
Northwest.
on northwest side of Route 44. Okay, that comes through a culvert. Okay, and that culvert, I don't believe, Tom, you might have enlightened me on that, the length of that culvert. It's not more than 200 feet, is it?
No, I don't believe it is. I
Yeah.
think it's more on the order of 40 feet or so
Yeah.
to our old plans and
So,
records.
so if it was more than 200 feet of a culvert, then you can say it's not a stream under the definition of the Wetlands Protection Act. But there's a clearly an extensive wetland system that is tributary to that, and hence the argument that it is a perennial stream, because it does have, based on preliminary stream stats, you have more than half a square mile, basically 320 acres of area that drains into that. And there's a defined channel. I mean, so it's very hard to make the argument that is not a bank. It really is.
Yeah, I think our view on what's in the northwest quadrant is that it's land subject to flood. It's not, that again is not a wetland, but I defer, Frank, if you want to say a few words about that.
Sure.
Stop talking.
This is the most recent USGS map of the area. Oops. And this is the area of concern, this property. As you all know, within the Wetlands Protection Act, you defer to the most recent USGS map to find a solid blue line that would indicate a perennial stream, which the Taunton River clearly is. However, there is no perennial stream that goes through the back of this property. So by definition, that component of the definition of a perennial stream, it's not there. When it comes to the stream stats, of course, we'd want to look at the whole area and determine the connectivity of all the culverts entering into this area. If you move back to the definition of a water course, once again, it's a natural water body or an altered water body, but drainage channels are specifically excluded from the definition because of that. We'd also take the position that the BVW, therefore, would fall out, because with nothing in for it to border, you don't have a BVW.
That stream, you can actually see it's not a solid blue line. That's why I already looked at that. That's why I deferred to the idea of the half a square mile.
But without making that determination,
But
we're speaking.
but it's still, see, so the argument then is, if one were to say it's not, put the enforcement order aside. If the commission says you gotta file a notice of intent, or even with your RDA, and it makes a positive determination, your argument does not negate the commission's position until you go to DEP. That will be the next level of, for the lack of a better word, arbitration, if you will. So it goes to DEP, and if DEP renders a decision that one of the parties doesn't like, then you can potentially go to the adjudicatory hearing in Boston and or the Superior Courts, and then they can make that determination.
Agreed.
But I don't see how you can argue, that stream has been there for eons. It's still shown. The argument right now is it's not shown as a solid blue line on the current USGS map, but it still shows up as a stream. So even if it's intermittent.
I can pull the topo map, USGS topo map from the 1970s, 1974, I believe, and it'll show that that stream is no longer there, which predates the Wetlands Protection Act. So once again, there's a question of jurisdiction. You can't regulate something that predates the law. And that's what we'd like to present in the RDA, is to basically spell all this stuff out so the commission, at your discretion, of course, but allow us to present the data that we found, the soil borings that we've conducted, the vegetation analysis, the hydrology analysis, and allow you to make a decision at that point. If you give us a positive determination, well, we'll take that and, move forward. Our hope is that, through the basis of this evidence that we provide you, to move forward with the remediation, either under the enforcement order or under a negative determination with conditions, and, make this right.
Again, the other option, if the commission weighs heavily us doing the work immediately, you could amend the enforcement order to remove that condition, and then we would get it done this season, for sure.
But even if we chose to go that route, that still is not, we would not be making a determination either way on the stream at that point. So if there was any further activity that took place in this area, we would still stand where we are today. So it would go to the same point, because our belief is, at very least, it's intermittent.
I think if the enforcement order was amended and we kind of punted on this issue right now, I think our case certainly understands your sensitivities, and I think if there was any future work done in this area, we'd start with an RDA and get a determination at that point, and then proceed accordingly. So you're right. I think we wouldn't necessarily resolve the issue, but we get the work done, and we'd save everybody a lot of hassle. And then down the road, further work, I think everyone's aware of the sensitivities. We'd start off with at a different regulatory point.
We haven't even seen a replanting plan.
No, you haven't seen an idea. What I will suggest, Mr. Chairman, I will suggest that, yes, you could amend, and I agree with that position. You could amend your enforcement order to allow the restoration work to commence immediately while the NOI you're requiring can be pending. In other words, I don't think you want to take out completely an IDA or NOI filing completely, because you want to somehow resolve that issue.
But the only thing I'll disagree with you on that, Azu, is if you allow the work to happen without the proper documentation, we'll call it, and settle the argument now, that it's going to just fester and just stay there, and I don't know what the company's intentions is, but there's a for sale sign out front. It could just get passed on to the next owner. I think we need to settle this right now, and I will go as far as making the motion to reaffirm our vote at last meeting to enforcement order and reaffirm our request for an NOI. I'll make that in the form of a motion.
We have a second on that? Second for
For
discussion.
discussion.
If I could, Mr. Chairman.
Well, hold on, let me hear with this. Do we have a second for discussion?
In terms of your enforcement order, it's still, you don't need to re-emphasize that, it's still in force. You know what I'm saying?
Yeah.
It's still in force. The only vote that you would have had to take is if you wanted to amend it.
No, all right,
So if you're not amending it, your enforcement order is still in force.
yeah, no,
I
I'm,
got a question. What is your client's future in this property? Are they there for long-term? Are they selling the property? Is there going to be construction? Because it seems like a lot of work is going into not getting an NOI. And I only see it as, well, if we do an NOI for this, when our future project comes in, we got to do another NOI and another NOI. That's the only thing I'm thinking right now, because as our chairman said at the last meeting, your client was more than willing to go forth and knock out whatever we need to do, but now there's such a roadblock about an NOI, it just leads me to believe that there's more NOIs or more fear of more NOIs down the line.
Yeah, I don't know specifically what RK's plans are for this property. I ask them certainly. I'm not aware of them looking to do, and there's no future project that I'm aware of.
Are they afraid it's going to hold up a sale maybe? Because I know when you do the
No,
NOI, order conditions and...
I think the resistance to the NOI is just what I said before. You're consenting to the jurisdictional status of this land that's adjacent to their property. And where they have a strong conviction that it's not jurisdictional, it's not subject to the Wetlands Protection Act, they just don't want to concede that they need to file an NOI. That's it. And I've worked with a lot of developers. They just don't like to concede that there's regulatory jurisdiction over something that really is not.
But if those swales are to collect drain water, stormwater, and then that brook drains into the Taunton River, which falls under the DEP,
Yeah.
how does that not fall under the Wetland Protection Act?
Well, if I could just say, those swales, they were constructed specifically for that purpose, and we submitted plans, original design plans from the 1970s with our RDA that show the design of those drainage channels. So those bricks were constructed specifically for stormwater conveyance. And again, I think that buttresses our argument that we're not in a jurisdictional area here. So yeah, that's they're drainage channels that constructed for that purpose. And what the recent work that MassDOT did in the area,
Who constructed it?
I believe it was the original developer. It was a Kmart
Okay.
Plaza
Yep.
originally.
So you're saying the drainage swale, intermittent stream, perennial stream, was constructed in 1970 on state property?
It would have been done in conjunction with DOT and their drainage work from 24. So, I mean, I have a plan here. This is the one.
Actually,
And this is the area here. You can see the grading plan for picking up that channel coming from the highway. And these are tied contours to the building.
If I could just add, somebody asked the question about
It would have been
the
better.
grading plan, so that the restoration plan that Arcade would implement here. We met with MassDOT a couple weeks ago to talk to them about that, so we're waiting for input from MassDOT on what kind of plantings they want in this area. I think there's some issues with the sight lines around that horizontal curve that goes onto the ramp. So definitely want to get, be in coordination with MassDOT on what we put there so we don't create any safety issues.
This is essentially the area of the restoration where the trees were cut and such. And these were the species, there was a couple of invasive species that we found out there, so we would propose to not return those to the area, but go with the more native species. And once again, based on MassDOT's approval, we would only want to be getting a large crown tree, obviously along that curve there where it would inhibit the sight line.
MassDOT?
Yeah, we're waiting for a revegetation plan.
Actually,
That was
just-
supposed to be part of the notice of intent. Revegetation plan and also a drainage analysis and the stormwater regs. Those are basically direct discharges to what appears to be a perennial stream that goes down to the Taunton River, under Route 24, into a stream continues. We have plans here from 1932 that show that as a named brook called Pale Brook.
I have it in 1855 downstairs.
Well, I looked at also the historic USGS maps, and nothing was on the, just like the current USGS map, nothing was on the 1944 revised to 1949 USGS. But the 1893 USGS also showed that brook. Just to the east of, there's the Forge River first, and this Damlock Brook, and then this Pale Brook.
I wouldn't deny that.
Then Route 44 was built around that, and so wasn't Route 24 after that. So that goes all the way down to the west side, the east side rather. It goes down here, cuts across under this interchange loop, into this area right over here, and then down into the Taunton River on the east side of Route 24. And this drains this whole area up here. You can see as wetlands. This inner loop of our interchange is all wetlands. That comes out to Pale Brook also. And this inner loop is also all wetlands. That comes out to Pale Brook also.
The inner loop is all wetlands?
These two.
Yeah,
Okay.
pretty much.
What's the distance from that inner loop to the back of this property? It might be 100 feet right there.
From here to here, you mean?
Across that ramp.
These two.
Across-
I don't know,
This
we'll
one is
have
not.
to scale it off.
These two.
But that all part of what I'm saying is more than half a square mile area that drains into that brook. So I obviously haven't had a chance. I know they submitted an RDA, but I haven't really looked at it because you were going to request a review fee either way,
Yeah.
whether it's an RDA or an NOI. But I have a hard time just based on physical characteristics out there on the site and looking at the historical maps. I have a hard time saying that is not a stream, that is jurisdiction. I don't know how you can make that argument, but
Well,
it's only my opinion.
There were actually two issues, I think, in your enforcement on it. One was the tree cutting and the revegetation. The second one was the drainage.
Yeah.
Currently, those, as far as I can tell, are direct discharges of runoff
Untreated-
into
untreated
that
runoff.
stream. Yeah, untreated runoff. into
And we do
that
address
stream.
that within the
Now,
RDA.
those waterways were built in 1975. That was well before the stormwater requirements under the Wetlands Protection Act.
Correct.
And so, MassDOT does not allow people to take their water and put it onto our property, basically. If you can handle your water on your property, that's where it's supposed to go.
It was part of the discussions we had with Mass DOT, actually, and
The argument that I had made at the last meeting was if they had left those swales be, because they were installed prior to any law, back when Kmart Plaza owned it, it would have been fine, but they have gone ahead and done work to those swales, sort of redo the riprap, which now would place it under today's law. That was the argument that I made at the last meeting.
Yeah, those were, we would look at those as maintenance activities. We didn't change, we didn't change.
it wasn't
channel.
riprap before, it was asphalt, correct?
correct.
Okay, so you did change it.
So that's not maintenance, and there's been a gate installed.
A gate where? A fence?
A gate in the fence, there's been cutting along the fence, there's been herbicide applied along that fence.
Correct.
And
Yeah, and one of the reasons that
That's
MassDOT,
modifications, to me, that's not more than maintenance. That's some large modifications, from changing from asphalt to riprap.
so I believe MassDOT did a lot of work there. I think it was in January 2013, because there was an issue.
Yeah, that was last year, last fall.
Last fall, because there was an issue of stormwater coming onto the arcade property into the back of the parking lot. So I believe that sort of started in that area.
Is
And-
that why it was done?
That's ostensibly the reason. I don't know, that little brook there would have to pump itself up about 5 or 6 feet, I'd say, to get over the slope and into Arcade's parking area, but
It was
so we
flooded.
requested that the Bristol County Mosquito Control come in and clear that out. And they're, of course, exempt under the Wetlands Protection Act. We also
And
had,
that's true maintenance.
yeah, we also had our notice of intent and order of conditions under the drainage systems maintenance program that we have.
Right, so
Not to
that,
mention the fact that you did call.
right,
and
and then
discuss
also.
it with us.
Right, and then also, with the notice of intent, recognizing that as a resource in their notice of intent, and.
I would disagree with that, sir.
and-
It was
and-
not in the notice of
And
intent.
actually, the work that they did on the arcade side of the project, that stream, you can actually see where they breached the bank. You can actually, it's still exposed, okay? You can see the sand composition of that stream. And you can see the formation of the stream bed. It's really a resource.
Where did they breach the bank?
Right where they put the 3 swales, the stone pads
Yeah.
for the drainage out of the parking area.
Right in the area
Where
of the
they,
gate.
where they install the new gate on the fence.
Where they put the riprap down?
Yeah, right there,
Where
it
the
goes
fire
right into
hydrant is.
goes right into the bank of the stream. You can see it. It goes right into it. So that is a breach of that bank right there.
Well, my original point was we're working with MassDOT
Yeah.
to talk these issues through.
MassDOT owns the property. It's under our jurisdiction. What you did, what your client did, was wrong. I still contend that. So we don't have a planting plan to look at, even if we were to try to do this under the enforcement order. My concern is the plantings. I mean, at this point, you're going to, if you're lucky, you get on the 18th meeting.
Well, they're gonna get an agent meeting for the RDA anyway. They have an RDA filed with you. You gotta.
That has to be
you gotta get
filed, but before that even gets noticed, we have to have consulting fees,
We can get those to you.
okay?
Tomorrow.
If you tell us the amount, we can get them to you tomorrow.
I will email Gail and.
An estimate.
Including the changes that we found.
In terms of the planting plan, I would like to commit to you that we'll get it to you ASAP, but I think.
There is a restoration plan within the RDA that we've provided. The exact locations and, like I said, we leave that subject to Mass DOT, but the actual volume of wood that we are going to put back in the ground is stated specifically in there.
Sizes, everything?
Everything that you need, I believe.
Was there a preliminary plan, Frank, or
Yeah,
was it just
it's-
discussed in a narrative?
It's discussed in the narrative, and it's this plan. Shows the area of restoration being this entire corridor here. And then the specific trees we'd be putting in there.
What's the sizes?
Before we go there, Mr. Chairman, I don't feel comfortable talking plantings and restoration work without the notice filed. We're getting ahead of ourselves.
I would like more information before I would entertain a different type of a motion as to if a planting plan, to me personally, would even be acceptable.
Well, but I mean, I think if they filed an ADA. You require an NOI, which is still outstanding, because you're.
We still have a fine that's in place right now.
It's still, but, you gotta follow due process. If your plan is included, and you're talking about senior planting plan,
Then I'm
you have to hold
opening
it,
up the ADA. Okay.
you're almost basically opening the
All right.
ADA without a notice in the paper, and without the abutter notification.
We can't
That's
talk about
pulling the cat before the horse.
I think
Okay.
that's what
So we
Tim's
did
point
send
is.
out the abutter notifications.
Yeah, no, but I mean, trying to discuss a planting plan that is part of an IDA is almost a back door
Can't
way
use
of
it.
getting into the hearing without actually opening the hearing.
Enforcing the IDA on
Yeah,
us,
yeah,
and I disagree with that.
But you still they have a right to file an IDA, that's their right.
That's their right.
And you have to hold it, you have to hear that IDA and then make you a decision on the
That's correct.
IDA. Your enforcement order still stands.
That's right, it still
Absolutely.
does, yeah,
And the enforcement order still
stands.
has been
It's still in
violated.
effect.
Yeah, but it's been violated. I mean, the fine was
Well, they
supposed to
haven't
be.
met the requirement, you included a fine structure for each time it's not in, I mean, the applicant, our key people that were here, and they agreed to it, they said they didn't have any problem, and they were gonna move expeditiously. So, which kind of ties to what I believe Dave had said, or Bill, I'm not quite sure which one of you said it, but the fact that your client came here, okay, and said, this is whatever we gotta do, we ended wrong, we wanna make it right. The contractor that did the work was here, and said they wanna make it right, whatever they gotta do. And so it's almost like, almost trying to lure somebody to sleep before you whack them.
Yeah,
That's-
they're not changing
You
their
know,
position in
so
terms of,
that's-
wanting to.
I think it does not, you could probably have, I mean, I understand with the RDA, and they have the right, and the commission, anytime you receive an application, whether they like the application or not, they must hold a hearing on every application that is submitted, okay? I mean, we can't quibble with that, that's statutorily, they have to do that. But I'm taken aback that it's almost like your client, it's like my kids. Okay, they had no problem, and they still don't do it anyway, come on.
My kids are the same
That's-
way, and I tell them they're lucky they're cute, because otherwise they'd be in trouble, so.
So-
It's easier to ask for forgiveness than do it the right way.
The only thing to keep in mind is, what surprised my client was the requirement for the NOI, not the remedial work that was requested or ordered in the enforcement order. So when they came here and they said, we're happy to do whatever it takes, we'll make it right, they weren't aware that they were going to be made to file an NOI.
No,
Yes, they were.
They were.
They were
Because-
sitting right there.
Because the enforcement order was sent to them, and they were invited to the meeting, so they did know that. As a matter of fact, that night, they
They
requested
requested an extension.
they requested an extension on the time to file the NOI to August 19th. And then,
That's
right, and then, Dave, right?
26.
Frank, said, hey, listen, we cannot disagree with this, but we still want an extension, just to preserve that, and you can see, they're saying they want to do the work, the commission says you violated the act and the bylaw, right? And they say, yeah, we want to do that, but we don't believe you have a jurisdiction, but we're going to do it anyway as good neighbors. So you can almost see too, where they're telling the commission, hey, you don't have jurisdiction. Then how can the commission turn around and tell MassDOT for future work that they're doing, that they have jurisdiction?
Well,
You know,
again,
so-
MassDOT is doing work in different areas along a
Yeah.
longer corridor that, I
So,
believe is jurisdiction.
so that's really the issue here. So somehow, that issue of the risk somehow needs to be, ultimately, whether it's through the DEP or even through the IDA process. Whether it's adjudicated down the street, down the road, that it is or not, but that really, it's important, because if the commission doesn't have the jurisdiction, then the enforcement order, it's out of order.
Yeah, and my client is still
Yeah.
going to put the plantings in the
Yeah.
ground. So, we're not going to back away from that commitment. I understand that it could kind of take the whole enforcement order off the table, but I think they're still committed to do the right thing to make you happy. If I could
Would
just
you
ask...
like to see the minutes of the meeting?
I was just
Shows
gonna...
exactly
I was just
what was
gonna-
said?
I was just going to ask, I looked for minutes online. Are the minutes posted?
Just approved tonight,
Just
so.
approved tonight.
Mr. My pronunciation, Penua, asked the commission if it would ratify a restoration work under the enforcement order. Mr. Azu stated that finally the notice of intent is so that the restoration can be regulated. Therefore, the project would have a working document. Mr. Kratz stated that it was their mistake in that their relationship with both the Raynham Conservation Commission and Mass DOT was important. Whatever is necessary, they would work together to do this. RK Associates will meet with Mass Highway in order to come up with a plan. The property is not, with the plan, the property is not theirs, and the owner is owned by Mass DOT. Mass DOT has submitted numerous notices of intent. Mr. McGuire knows exactly what the commission is looking for, and he advised Mr. Kratz to work with Mass DOT. Plain and simple.
Yeah, I wasn't there and I haven't seen the minutes, but it sounded like
They've
there was
already
there was some...
agreed to do the notice of intent.
Can I ask a procedural question? The enforcement order, was that voted on for the first time on July 29th? Or was there an earlier vote by the commission?
Was ratified.
No, it was just, it was voted, it was voted that night.
That night?
Okay, it was issued by the chairman, and then the commission obviously had to ratify it because it was been.
It was issued on the 29th, it was voted on the 8th, I believe, it was, or the 7th. So prior to the 29th, were there any votes taken by the commission?
There was no meeting.
No.
Okay,
Yeah, just a point of information, Mr. Chairman. The original enforcement order required a notice of intent on or before August 19th, and I think at the last meeting, the arcade folks asked for an extension. You said, okay, but the latest we can give you is August 26th, because you needed to put an ad in the newspaper for tonight's meeting. That's all.
and we
But it
voted.
is right, the enforcement order,
Right, yeah,
requiring a notice of intent.
right, yeah.
So we're spinning our wheels here.
Yes, we are.
So you probably want to give them a date anyway for, at least for the IDA hearing.
Okay,
Because they are responsible for putting it in the paper.
the next meeting, September 18th is the date for the IDA.
All the instructions are in the regulations, filed with the Daily Gazette, put it in, it has to be 5 business days before the meeting, so.
There will be an
And
estimate
they do have a
prepared.
lead time
Right.
to be able to meet, for them to put in the paper. So you probably want to contact them tomorrow.
Not a problem.
There will be an estimate prepared.
I'll forward it, and then Gail will forward it to Mr. Barrett.
And there's an issue with the fees that has to be rectified before.
On the IDA, yeah.
Yeah, on the IDA.
So, again,
Dave, can you
procedurally...
shut that door, please?
Would we expect we probably wouldn't get a decision of the RDA on the 18th, correct? Maybe, maybe not.
Well, no, unless you request a continuation of that. Technically, the commission has 21 days from the filing of an IDA to issue a determination.
Right.
So they have to issue a determination that night unless based on the discussions, you feel on your client's behalf that it is necessary to continue that hearing. But I think they have 21 days to issue a determination from the date of filing.
My concern is with the enforcement order, because we have only so many days to appeal that, if we want to. And that's going to run out at the end of September. So if we don't get a determination on the RDA on the 18th, then we're going to be close to that deadline. That's all.
No, they have to issue a determination on the 18th, unless you specifically, on your client's behalf, felt that there's a need to continue that hearing.
I don't think we need a determination exactly on the 18th, but within a couple of days after that.
Or they wouldn't have another meeting
But you don't have a meeting.
until October, right?
So it has to be that night, so we can vote.
Okay.
Mr. Chairman, also as a property owner, we would need a copy, notification and a copy of the RDA.
It's been submitted to
Yeah,
you.
complete package. Have you sent it to us?
Yes. Should have the green card back shortly.
I saw a couple of green cards come back, but I don't know, didn't check if it was mass. All right, thank you, everybody, for your time.
Thank you.
Excuse me. I get it. You got
Hold
it?
on.
Never mind.
We're still open on this. Now,
Enforcement order continue?
well,
Yeah,
here's my question. We voted to issue a fine if something wasn't done by a certain date.
That's still on.
Well, it wasn't done, so where do we proceed with the fine as part of this enforcement
Well,
order?
the fine stays.
But are we,
They already voted that.
but are we authorized to issue a fine if the RDA comes back negative?
No,
I'm trying to put
You're
fines
not
out.
ahead of yourself. That has nothing to do with your enforcement
don't-
order.
The reason that we we set a fine, correct me if I'm wrong, was if they did not submit a notice of intent by the 26th, then they were to be issued a fine of $6,300.
Right. And they did.
That did not happen. Am I correct or am I incorrect?
No, your vote was that to fine them, not whether they filed a notice of intent or not, for the violation. That was an infraction. And then you were gonna lift the fine if they meet all the requirements. If they're done, then the fine stays. You didn't say if you file a notice of intent, then you don't file. No. That says you're paying a fine, you have a fine instituted.
Okay.
And then it says, if they work to meet all the deadlines, then you will take a vote to rescind the fine.
Okay.
So that still stays.
There was just one thing that I saw on site, was that pile of dry brush. That is just inviting to a match from a kid or whatever.
Right by the edge of 44?
Yeah, and I just think that pile should be picked up, just to avoid any nighttime issues. Does anyone agree with me on that one pile of brush on the parking lot side of the fence?
I do, I agree with you.
If it's on the parking lot
It's on the
side?
Parking lot side of the
I know which
fence.
one you're talking
Yeah.
about. Yeah, if they want to remove that.
Right behind it's a party, right in the alleyway there.
I would like to see that removed just for safety
Yeah, just pass
issues.
on the information. You don't need to take a vote on that.
Okay.
Make sure that happens.
So we will continue the enforcement order.
You don't need to continue, you don't need to take
It
a vote to
stays in it.
continue. It's-
Okay.
it's info- Yeah,
Okay. Any further discussion? And we'll move on.
you got it.
Thank you, Tom.
Enforcement order for Mass Dot. I think we already discussed it.
You made him get up and sit down again.
We're all set with that,
Yeah.
right, everybody?
Two birds with one stone.
Thank you.
Thank you, Tom.
Okay. We have a continued notice of intent for DEP file number 269-08902T's Realty Trust, 152 Forge River Parkway, map 14, lot 2420.
They were supposed to be here tonight. I have didn't get any notice of continuing it or anything.
We have a bylaw that allows us to fine them if
That's when I were talking about that today.
we should,
And I specifically reminded them last time because it was a new bylaw.
right,
And I called her and told her, if you're gonna continue, I need the letter.
right.
And they got it in right away. So they knew about it, but I've heard nothing from them. They didn't continue. I've gotten no emails, no letters, nothing,
No phone calls.
nothing.
Then we need to issue a fine.
So in other words, this cannot be continued until the fine is collected, correct?
No, you gotta continue
We gotta
subject to,
continue?
subject to receiving that.
Okay.
And if they're not paid, then you close the hearing and deny it.
Okay.
Deny, right, and it's
Okay.
not a fine per se.
It's not a fine, it's a procedural charge, it's not a
Charge,
fine.
yes, a fee,
for-
correct.
For not making the meeting.
Yeah, it's a fee, it's not a
Right.
fine.
Right now, it's a
fee.
$50 fee,
So do we
correct.
need to make a motion to issue the $50 fee? Or is that just,
Motion to continue this, subject to,
Yeah.
Receipt of a
receipt of a fee.
Make a motion to
That's required under the
continue,
bylaw.
subject to paying of any penalties or fines.
second?
okay?
All in favor?
Aye.
Opposed? Continued to our next meeting,
Okay, you get to leave for a minute.
subject to paying a fine.
This is real quick.
Apologize for the late.
The Bumella one.
Mm.
Someone needs to read the letter. Bill has to excuse himself. Make a note that Bill excused himself from you.
Okay. Do we need to read, this is formal?
Read that
It's correspondence.
Yeah, so it's not, you don't have to read.
relating to the letter that we,
Right.
notice of violation that we sent to George Bermillo.
All right, because there's another enforcement.
Right,
order
so
on that.
we sent
Okay,
the bill
right.
letter, and then basically you read that letter, and then I can explain.
From George Vermilia, 150 Winthrop Street, Taunton, Mass. 02780, to the Raynham Conservation Commission. RE, land at 262 Southwest Map 14, Lot 51, Raynham, Mass. I would like to request a new appearance date due to travel plans that conflict with my appearance date of September 4th, 2013 at 5:30 p.m. Signed, regards, George Vermilia Jr., 8/23/13.
So basically, this is the property that we got notified on. He dug a pond,
yeah.
breached the bank of the pond, worked in the drainage channel that actually takes the water from the pond to Forge River, and then stomped a tree. And we sent him a lot of violation and asked him to come to the commission's meeting. And then he did call right away and said that he had travel plans and would be out of state. I said, well, send a letter to the commission,
Okay.
and then if the commission feels that it's appropriate, then they will give you a new date. So I would suggest that we give him the date of September 18th to appear.
Where is the actual pond?
Well, the pond actually does not belong to any
Of the
one of
abutters
the
of the
three
pond.
properties. Basically, here's a pond, and the three properties come in to the pond. So they have ownership right to the bank of the pond,
Okay.
okay?
And
So
this is off of South Street?
You know where all the flooding was when we had all the flooding with the
Behind Stop and
houses?
Shop, down there behind,
Not, closer to Shaw's.
yeah.
Oh, okay.
Right behind Bernie and Phil's there.
I was thinking it was
Yeah,
the
Bernie
other
Fields,
side.
yeah.
It's where the guy has the construction equipment,
Yes.
central loam out
Right.
front there.
That's the same owner.
Which is the back side of the kennel
right.
area.
Yes,
Okay.
yes.
All right, now I
Yeah.
couldn't picture where it was. All
Yeah,
right, I
that's
apologize.
where,
Now I know.
okay. So he did not deny doing work. He says he was trying to clean up the area, and then I said, well, you needed to file, or at least notify the Conservation Commission. So he's making the effort, so come on September 18th, and
I would like to at least hear from him
Yeah.
personally. I don't want, so if that involves continuing, I'm all for continuing, because I'd like to have the actual person that we
Yeah.
enforced physically
Right,
here,
right.
instead of
And
continuing
he did
enforcement.
call right away.
And
He
with
didn't,
a
and
plan
then
to
sent
mitigate, yeah.
an actual sent a letter.
I have no problem that he made an effort to,
Yeah,
so we'll continue to, make a motion to continue to our next meeting,
the 18th.
the 18th.
All in favor?
Aye.
Aye. Unanimous?
You call that Bill back in.
So we'll send him a letter, so
Just because you're sitting in my chair doesn't mean you're second in command.
so we'll send him a letter.
That's what you get for being tardy.
Let's see, you're tardy?
So we'll send him a letter, all right?
Tell him it's continued.
Yeah, then,
Boy, I just got
yeah.
whipped.
So, I talked to David about this today. There was a call to the selectmen, and then from the selectmen to me, about Patriot Recycling, a huge pile there. I called David, he was driving by there, and said that they crushed their pile. It was actually further from the wetlands, so it was not a...
Okay.
And it's a mountain, I guess.
It is pretty big
If that's
pile.
the issue that was at hand, was
It's the pile that
the
nobody can
big pile
miss.
that they had to the right-hand side, they started processing it, and they moved it towards the center of the parking lot when they crushed it. So, I mean, the thing's 40 stories
Oh,
high.
it's huge, yeah.
And it overflowed the barriers that it had set up there.
Turn the mic around.
Closer to the wetland.
It overflowed the barrier that was there, but it actually,
It's further to the parking lot.
the big pile is now farther from the wetlands than it was before. What is going on beyond that area, I have not gone through there. So if that's the issue, we need to go take a walk. But if not,
Yeah, it was the...
The big dirt pile.
What's the big mountain?
that's what it is.
Yeah, I actually, when I saw the big mound, I drove through the lot in front, and it looks like from our initial walk last year, it looks like it's actually less between the buffer of the mulch burn that we had them create is less now. It looks like the piles are smaller in that area, but larger in the parking lot. So if anything, they're actually getting further, they're moving more material away, which is better.
But that, if someone is concerned in going to the selectmen, the selectmen need to in turn contact DEP, because they're the regulatory
That's right.
of the permits.
Yeah, for the solid waste,
For the weight, for the amount of waste in,
transfer station, really.
yes, is he in violation of his tonnage? That's a question they can answer, and only they can
So
answer.
I think if we look at the original plans from last year where the engineer flagged everything, that new mound, if I'm not mistaken, is out of our jurisdiction now. That mound is out of our 100-foot buffer.
Okay. Was there anything else? All right,
Want that last good final motion?
let's get it done.
Motion to adjourn.
Second?
All in favor? Aye. It's over.
I oppose, I'm just gonna stay next to the fire.